The stone room next to the town hall smelled of damp parchment and rancid lamp oil. On the table lay a marriage contract, stained with wax and neat corrections by the notary. A thick thread stitched the pages together. The dowry, the promise of mutual assistance, the witness marks. Next to it lay the complaint of the spouses, adults exhausted by mutual claims. He referred to duty, she to the violence of custom in his family. Underneath the documents were expense receipts for courier services to the bishop's court and copies of decrees from the papal chancellery. In this pile of papers, a domestic quarrel turned into a question of power. Who decides what is considered normal in the bedroom of family life? Tribal elders, noisy relatives, or a Roman text written in clear Latin about voluntariness? A male voice greets the audience, asks them to write in the comments where they are watching from and whether they have encountered cases in their own regions where custom has silenced the law. He says that your stories are important for understanding how myths obscure documents and wishes you calm attention and pleasant listening. The notary, an adult with calloused fingers and a hunched back, carefully placed the complaint alongside the originals of the decrees dating back to the beginning of the 13th century, when Rome was ruled by the Pope, remembered as Innocent III. He was taught not superstition, but form. Where to put the remark heard, where to write answer given, where the word consent should stand before the word cohabitation. In the margins, he habitually left headings: will, coercion, custom, family interference. A separate thread was the medical notes of an adult doctor, with notes about his wife's bruises and exhaustion after prolonged quarrels. There was nothing sensational about them, just a cold record of pain. The notary noted that where the husband's family insisted on duty as a compulsory obligation, reality was harsh. Insomnia, fear, refusal to eat together. He picked up a collection of decretals where dry Latin repeated the rule that came from law schools. Marriage is made by consent, not by mere form or pressure. He ran his finger over the lines that required the publication of announcements before the wedding, so that everyone had a chance to raise objections. Where marriage contracts without free will were declared null and void, where suspicious consents under fear or pressure from relatives were resolved in favor of freedom. He was not interested in the ideal, but in how this paper worked in the mud of provincial life, where elders habitually decided for new spouses. At the town meeting, the adult men of the husband's clan referred to our customs, the proper order, and the authority of Rome, understood as permission for oppressive supervision. The notary discreetly noted in the margins the myth of total control. The investigation began not with loud words, but with comparisons. In what sequence did conflicts arise? When did the husband's family increase pressure? What words were used to justify the demand to fulfill one's duty? And when exactly did threats to deprive the wife of support appear? The expense sheets for the case included the costs of traveling to the local archdeacon and correspondence with the diocese, At the same time, the house register recorded how adult witnesses, neighbors, godparents, heard nighttime quarrels and saw the wife hiding at her relative's house. The notary, verifying the details, did not look for juicy details. He was interested in where coercion entered the conflict and where the document gave him a name. He compared the everyday councils of elders with papal norms, compiled by people who feared not feelings, but violence. In the decrees of the early 13th century, the emphasis was on voluntariness and clarity of obstacles. Marriages under threat were prohibited. The invalidity of vows extracted by force was declared, and the role of mutual consent as the essence of the union was emphasized. The notary recorded these provisions in the affairs of living people, where the usual duty became a club for control. He noted that the elders referred to the bed as a duty of the family rather than to the text, where the union was built around consent and agreed obstacles. The turning point came when the elders again hid behind custom in the minutes of the meeting. They tried to assert that, in our region, a wife is obliged to do everything that her husband and his household require, and that Rome allegedly always blessed such discipline. The notary raised the paragraphs on marital consent and reminded the court that what the family was referring to was a late legend of total control, convenient for exerting pressure but not consistent with the sources. He attached to the case excerpts where the papal chancellery, on the contrary, required verification of voluntariness and punished coercion into union, where the independence of consent was protected from coercive measures accepted in the community. He did not need fine words. A dry formula sufficed, in which a union without freedom is invalid, and a duty extorted by fear is not a legal right, but a violent fiction. The conflict unfolded as it always does in such cases. The husband's family began to exert pressure using the authority of Rome, in reality hiding behind not decrees, but their own desire to control the young family. At the city assembly, the adult men of the family threatened to refuse help, shamed the wife with words of disgrace, and hinted to the husband at the shame of weakness. The doctor noted in his note the deterioration of the wife's condition, and her adult relatives intimidated her with retribution if she went against the world. The notary recorded each threat as an event in the case, the pressure of tribal custom and its clash with the norm, which Rome attributed not to fear, but to consent. He drew up a comparative table. On the left, the formulas of custom, duty, obedience to the house, punishment, shame. On the right, the formulas of the decretals, consent makes marriage, announcements to exclude deception, the union is invalid in the presence of fear, the court is obliged to protect freedom. He attached to the case the testimony of adult neighbors and a copy of the parish record of the publication of marriage announcements, which was made in good faith, 3 times on the agreed days, without concealing any obstacles. This record stated that the marriage began as a contract between adults before the community. Everything that came later was an attempt by the Klan to rewrite the terms of the Union, hiding behind the myth of Roman control over the bed. At the same time, he compiled medical and household realities into a single block. Medical records mentioned headaches, abrasions from scuffles in the house, and progressive insomnia. The household book showed how the husband, an adult dependent on his brothers, began to spend more nights with his relatives. Money flowed into gifts for elders and feasts in honor of restoring order. There is no theology in these expenses, only control of bodies through the economics of shame. The notary, without raising his voice, put all this into a file, where the word consent did not sound like morality, but stood as a legal stop sign. His last step in this part was to refer to papal correspondence, which emphasized the duty of courts to protect freedom of marital choice and punish those who broke the will under the guise of family honor. He attached an excerpt stating that threats and violence in family matters were classified as abuse and subject to ecclesiastical correction. Thus, the document countered the myth. Instead of Rome imposing marriage, there was a Rome that, at least on paper, forced local courts to affirm voluntariness and punish coercion. This concluded the first round of the investigation. The dispute between adult spouses, raised to the level of customary policy, was met with a Roman text in which voluntariness was not an embellishment, but a supporting beam. The notary saw before him not saints and miracles, but a table where custom pushes out the will. The decrees bring it back. Next came the test of practice. How would the court behave between the noise of the ancestral hall and the quiet parchment? And would the paper have enough power to stop the heavy hand of the traditionalists? The notary began with a summary, where he put the dates, written out in words, and the events in the house of the disputing spouses on one line. The days of the elders' visits, the days of publications in the parish, the days when the doctor recorded the deterioration of the wife's condition. A pattern emerged from this series. Every time the husband's family held a council, the next day was followed by claims of debt and threats to withdraw support, followed by sleepless nights and brief notes from the doctor about trembling hands and pre-fainting spells. The secretary's routine translated someone else's life into lines, and in these lines you could hear how custom crept into the beds of grown-ups with other people's hands and other people's wallets. To prevent the words from spreading, the notary attached copies of the decrees to the case. Consent makes a marriage. A marriage without freedom is null and void. Coercion is punishable. Threats and economic pressure are classified as abuse. He added to this an excerpt from the diocesan statutes, where the advice to the judge was extremely sober. Separate worldly customs from the law. Check whether the union is broken by fear. He then examined the testimony of adult witnesses. Neighbors recounted with restraint that the husband's family came in a noisy group, that the wife was taken away from the shouting to her relatives, that the hearth was no longer lit at night to avoid visits from advisors. These details, far from legendary imagery, formed a social portrait of pressure, debt as a club, shame as currency. The expense reports included lines about small gifts to elders and meals to strengthen peace, after which peace became even more difficult. The notary compared these expenses with letters from the papal chancellery, and noticed how the myth of Roman control turned into a mirror. Those who referred to Rome in reality acted against what Rome had prescribed in its texts on freedom of consent. Meanwhile, the husband's clan increased the pressure. At the city assembly, the adult men of the clan referred to the honor of the house and the order of the ancestors, and tried to impose on the court the duty to bring the wife to her senses. The notary compiled all their arguments into a table and placed a short reference to the relevant section of Innocent's decrees opposite each one, which spoke of voluntariness, the insignificance of a union formed under duress, and the duty of judges to protect the will of the people. He did not argue about morality. He simply reminded them of the norm. This dryness led to the first serious turning point. While considering the case, the court officially requested copies of those very decretals from the chancellery. Local custom, with its conversational power, came up against a text that had a date and a signature. While the request was being processed, the notary examined another layer, the medical one. The doctor, an adult accustomed to the painstaking poverty of his patients, noted not only bruises and exhaustion in the wife, but also constant muscle tension, insomnia, and trembling with anticipation. This was not unusual for the courts of that era. In cases of marital conflict, such records were most often left out, but the notary included them in the file to show the boundary between the language of duty and the reality of the body. He placed next to these notes lines from the decretals about the sin of coercion and the difference between a legitimate request and a violent demand. Thus, the document drew on medical prosaicness, destroying the myth of supposedly blessed total control. When the copies with seals arrived, a restrained scene of review began in court. Adult jurors, dependent on the urban market, and local elders read the text, which placed consent above habit. This did not cancel out domestic wars, but it set a benchmark. If custom breaks the will, custom is punished. The husband's family responded with what they knew best. They increased the pressure, started talking about shame before the arrival, and hinted at ancestral memory. The notary stuck to the letter of the document. He attached a summary where the parish record of marriage announcements made according to the rules confirmed that the marriage began as an agreement between adults before the community, without any hidden obstacles. He also attached an excerpt from the decrees, stating that subsequent coercion does not create rights, but destroys them. At this point, money emerged from under the myth. New expenses appeared in the husband's household book: gifts to elders, peaceful meals, visits to mediators. The economics of custom worked as a lubricant for pressure. Lubricant. The notary wrote down, where they say Rome commands, they actually mean the house commands. And again, he turned to the document in which Rome commanded otherwise, to protect the freedom of marital decision and to punish those who exerted pressure with the authority of the clan. He emphasized that the decrees were not friends with folkloric rhetoric, they were friends with procedure. The court, relying on the texts sent, demanded that the husband's family explain on what basis duty was understood as a compulsory obligation. The answer boiled down to, "That's how we're used to doing things." Then the notary brought up the point about the invalidity of consent obtained under duress, and drew a parallel with the evidence of night visits by elders and threats to withdraw support. The doctor's note about his wife's sleep disturbances and panic attacks was placed next to it. This was the second turning point. Instead of the habit of regulating other people's lives in front of their neighbors, the court began to view the document and the physical consequences of pressure as a related reality. The husband's family tried to play on the authority of Rome in a different register, through quotations from sermons on marital duty. But the sermon was not the law. The law lay in the decretals. The notary raised another text in which Innocent demanded that the freedom of marital decisions be verified and prescribed the annulment of unions that had come about through violence. He did not ask for mercy. He asked for recognition of the fact. The pressure of the elders destroys the legal meaning of marriage. The court, already bound by its own request to the Chancellery, could not ignore this. It issued an interim ruling prohibiting clan councils until the end of the proceedings and providing temporary protection for the wife from night visits that threatened to disrupt her sleep and health. Thus, the document took another step, pushing custom to the sidelines. The notary understood that the case would not be resolved in one go. He jotted down his next step in the margins. Compile a chronology of all instances of pressure, attach excerpts from decrees with notes about voluntariness, add medical records without naturalism, but with an emphasis on the consequences. For him, this technique was more important than rhetoric. The myth claimed that Rome imposed intercourse. The paper showed that Roman law required consent to be verified and coercion to be punished. All that remained was to complete the procedure, based on the text, to issue a decision where custom would cease to be a club and consent would return to the meaning of the contract. This was not the path of a holy miracle, but of urban administration, in which the stone walls of the court and the damp folders of the office suddenly became a shield for two adults against the noisy hall of relatives. The notary moved from pictures of pressure to the place where the formula turns into a decision. He laid out 3 columns on the table. In the first, the minutes of the councils, with the exact dates written out in words. In the second, excerpts from the decrees, where marriage is based on consent and where coercion is declared a breach of contract. In the third, medical records of an adult doctor about the consequences of night visits, exhaustion, and fear. He attached this three-column scheme to the case as a reconciliation in which the myth of Roman total control clashed with Roman formulas of freedom. The court agreed to consider the verification as a framework. From now on, every mention of duty had to be checked against the question of whether the spouses had a choice and whether the bed had become an arena of family pressure. Through this filter, the custom began to crumble before our eyes. The first cracks appeared where the husband's clan relied on honor redemption and house agreements. Expense reports revealed gifts to elders and spending on feasts, which were called peaceful. The notary transferred these amounts to the economy of coercion column. He explained to the court that these expenditures were part of a mechanism of shame, a feast as a sanction, a feast as a reward for a submissive body, a feast as a tool for controlling the silence of neighbors. Next to it, he placed a paragraph from the decretals, where the requirement to verify the unimpeded nature of consent took precedence over local gift-giving customs. The court, accustomed to believing the world and the wallet, was forced to look at a text that contained neither feasting nor redemption of honor, but rather a requirement of free will, established as a rule. The notary then showed how the myth of Rome commands uses official words against their meaning. The husband's family referred to sermons on marital duty, but the day before, the same people had been shouting in the house and banging on the door at night. In his table, these two layers stood side by side. On the one hand, moral instruction; on the other, the physical consequences of nighttime advice. He emphasized the connection. Where adult men put themselves in a supervisory role, talk of duty turns into a threat rather than reciprocity. In the decrees, reciprocity and voluntariness were not embellishments, but conditions. The court began to cool toward the custom when it saw that it was too eager to feed on humiliation and fear rather than on law. At this point, an additional layer emerged in the case: letters from the Chancellery citing precedents in which courts had annulled marriage agreements that had been vitiated by coercion. The notary included these precedents as supporting cases and added a brief note at the bottom on diocesan statutes, where the boundaries of family interference lie and why the publication of marriage announcements is necessary. The meaning was clear. If the union was initially entered into in front of the community without hindrance, then subsequent pressure does not change its essence, but violates the norm and is subject to correction. The family tried to develop the idea of restraint, arguing that it was only a matter of restoring order in the home. Then the notary brought up the medical records and asked the court whether putting things in order could be accompanied by tremors, exhaustion, and panic attacks in an adult, if it was indeed a consensual marriage. No one answered aloud. The answer was already in the columns. Gradually, the language shifted from morality to procedure. The court issued a temporary ban on night visits by elders and required all participants to appear when summoned, rather than according to custom. This decision did not seem heroic, but within the city walls it meant breaking the old cycle. Now the pressure from relatives themselves became grounds for penalties. At the next hearing, the notary added a new verification to the case file. Complaints from neighbors about noise in the houses after the councils, the clan's expenses for intermediaries' fees, and next to them, numbers written in words from the decrees about the insignificance of consent under duress. The court imposed a fine for violating the ban on councils and officially warned the clan about the consequences of repeating the offense. The dry protocol pushed the foreign hand out of the house. The conflict exposed the main nerve. The husband wavered between the fear of losing support and the understanding that a marriage without freedom would collapse under the same ceiling where they were trying to strengthen it. The notary did not make a moral issue of this. He recorded the choice of an adult who had to answer to whom he gave the right to speak for himself. One day, after being persuaded by words, the husband appeared in court without the elders and confirmed that he had not asked for night visits, had not distributed gifts, and had not instructed anyone to speak on his behalf. This gesture, which seemed minor, became the third turning point. The construct of the family speaks for the house began to crumble. The court recorded in the minutes that further claims regarding the debt would be considered a dispute between the spouses, not between the clan and the spouses, and, in the event of coercion, a violation of the norms. The notary took advantage of the pause and brought out another key piece, the section on public announcements. He reminded the court that their purpose was to protect the freedom of marital decisions from hidden obstacles and sudden pressure. If, after such announcements, the clan begins to rewrite the rules under the guise of the authority of Rome, this is not loyalty to Rome, but abuse of its name. He placed a short excerpt about the punishment for abuse of spiritual rhetoric in a secular dispute next to it. For the first time, the court clearly called a spade a spade. Those who use custom to coerce and break voluntariness will be considered traditionalists. Once this word appeared on parchment, it ceased to be a swear word and became a legal label. The scheme then began to develop towards a resolution. The court demanded that the clan cease any actions that influenced the wife's will and confirmed the right of spouses to regulate the intimate side of marriage without external supervision, provided there was no violence. Medical records were transferred to control status in order to monitor the consequences. The notary concluded this stage with a case of fines. The amounts, written in words, were imposed on those responsible for night visits and peaceful feasts, where the fate of someone else's bed was decided. The mirage of Rome commands dissipated when Rome itself appeared more in the text than in the speech of the elders. This was the result not of an inspired sermon, but of the quiet pressure of paper, where consent was not treated as decoration, but was considered the foundation. It was in this silence that it became clear that the myth of total control was convenient for those who wanted to control bodies without responsibility. The document, on the contrary, demanded responsibility for the intrusion and called it by name. The notary summed up the interim results. Marriage remains marriage if it involves the free will of adults. Custom, reduced to a whip, is subject to fines and prohibition. The authority of Rome in the mouths of the clan is often a foreign mask that should be removed by comparing the text and the consequences. All that remained was to spell out the final steps. How the court would enshrine this in its final ruling, how the appeal would be arranged, and how the city chancellery would enter the new practice into its books, based on the decretals, rather than on noisy Soviet meetings at the bedroom door. The court proceeded to compile the final matrix of facts, and the notary laid out the last set of verifications before the judges. One column listed the days, written out in words, when the husband's family gathered councils and organized feasts to strengthen peace. The second column contained excerpts from Innocent's decrees, which once again confirmed that the consent of adults makes a union and that coercion destroys its legal meaning. The third column contained the doctor's medical records on the consequences of night visits: nervous breakdowns, exhaustion, insomnia. This three-lane roadmap removed everything superfluous from the dispute. It became obvious that custom did not serve as a cherished tradition, but rather as a mechanism of oppressive control, which the family used as an instrument of power over bodies and wallets. The court invited the parties to submit their final remarks, and in these remarks, the clan once again referred to the order of the ancestors, while the notary, maintaining his steady pace, returned the conversation to the text and its consequences, to the lines that pointed out the insignificance of consent under duress, the obligation to protect the will, and the punishability of abuse, of moral rhetoric, in a worldly dispute. At the same time, precedents were being filed in the office. The notary found cases where courts had annulled or corrected marriage agreements if pressure from relatives was discovered, and where fines were imposed for interference disguised as advice. These cases were sparse on details and full of formulas, but they created a ladder that the current court could climb to reach a clear decision without fear of offending the ancestors. Each such case featured adult witnesses, domestic quarrels, expenses for peaceful meals, and a final point about protecting consent. The notary brought the proceedings to this ladder, showing that the Roman text does not prescribe total supervision of the bed, but rather prescribes verification of freedom and punishment for pressure. The more cases there were on the table, the more noticeably the air of legend melted away. There was still a thin thread left, the rhetoric of duty as an unconditional obligation. In order not to leave any loopholes, the notary twisted the meaning of duty in a legal sense. He showed that in the decrees, duty is conceived as a mutual perspective of a union of adults, and not as the right of third parties to dispose of their bodies. If fear and economic dependence enter the home, duty ceases to be mutual and turns into coercion, from which the document commands protection. The medical records placed alongside made this abstraction tangible. Tremors, insomnia, and loss of strength in an adult are not a codified duty, but the physical price of public advice. The court recorded this turn of events, noting that debt cannot be collected by traditional methods and that it cannot be invoked as a justification for pressure. The husband's family tried to keep their footing with a final strategy, referring to the honor of the home and the need to maintain order. This formula usually covered everything from restricting visits to imposing a regime in the bedroom. The notary did not argue with words here either. He carefully placed an excerpt stating that references to honor did not negate the requirement of voluntariness and did not turn the family sphere into a public hall. Next to it, he filed a note about fines for interference if it was proven that the advice led to a breach of the peace, sanitary problems, and a threat to health. The court, which had gone through many difficult years and seen how destinies were broken under the guise of honor, did not risk leaving this door open. It confirmed the existing ban on visits and stated that in the future penalties would be imposed for each violation, the amounts of which would be recorded in words and collected from the organizers of councils and feasts. Meanwhile, on the spouse's side, a quiet process of unraveling the dependency was taking place. The husband, now an adult and finally separated from the nightly chorus of relatives, began to attend meetings without escorts and stopped financing the peaceful feasts. The household book reflected this. Expenses for gifts to the elders plummeted, and lines appeared about repairing the stove and buying warm clothes for the winter. These changes were not a feat, but everyday life, in which there were finally fewer outside hands. His wife, grown up and tired, stopped appearing in medical notes as a patient with panic attacks. The doctor began to write about the restoration of sleep and appetite. The court saw these changes and understood that documentary measures had a real effect. Where the hand of the traditionalists is removed, the physiology of fear disappears. To consolidate the practice, the notary prepared a draft city circular for the judges' offices. In cases of marital conflict, first, check the publication of marriage announcements, then the freedom of consent at the time of the union, then the intervention of third parties, then the medical consequences of pressure, and only then consider controversial issues of domestic life. This order cut off the family's favorite loophole, starting with moralizing and ending with violence. The circular was based on innocence decretals and local statutes, in which the protection of will was placed above custom. The court accepted the draft for consideration because it saw how it preserved the result not on paper, but in everyday life. Meanwhile, the city was busy rewriting the myth. Stories of Roman severity were still heard in the markets, but now they were accompanied by a simple example. A case where the court did not allow custom into someone else's bed and protected the right of adults to marital consent. Scribes double-checked the formulas in marriage contracts. The word consent was no longer hidden at the end, but moved to the beginning. Parishes carefully published announcements, not allowing elders to close obstacles with backroom negotiations. The change in rhetoric did not happen overnight, but every time another family tried to play on the authority of Rome, they were shown not a legend, but lines where innocent demanded the opposite: verification of freedom and punishment for pressure. 4. All that remained was to put all this logic into a final ruling. The court had to take several simple but dangerous steps. Recognize the clan's interference as unlawful. Find the organizers of councils and peaceful feasts. Confirm the right of spouses to regulate the intimate side of marriage without external inspection. Oblige the parish to publish announcements in accordance with the charter, and the chancellery to keep copies of the decretals in the files for verification. This sequence was not a revolution, but it broke the main link, the mythical connection between Rome imposes the bed and the family has the right to exert pressure. In reality, Rome defended consent, and the court was obliged to apply harsh practices to this: prohibitions, fines, and procedures. At the final meeting, when all the folders were neatly arranged, the notary looked once more at the first complaint and the wax-stained marriage contract. He saw how the case had progressed from the first lines about debt to words about freedom. He did not celebrate or preach. He did what documentary work teaches. He cut out a piece of the legend that was convenient for the powerful and replaced it with a formula where adults retain their free will. And when the judges went into the deliberation room, a shift was already felt in the city, not loud, but dense, like the weight of a fresh seal on parchment. From now on, the traditionalists would have to pay not only with feasts, but also with fines, and the authority of Rome would cease to be a club, because this club still had Roman words of consent on its handle. The decree was written slowly, like winter, and the notary made sure that every line was in its place, without embellishment or loopholes. In the preamble, the court recalled the publication of marriage announcements, made in accordance with the charter by the parish 3 times, on the agreed days, which confirmed the initial agreement of the adults before the community. This was followed by points based on the decretals of the early 13th century. Union makes consent. Consent extracted by fear is null and void. Pressure disguised as advice and honor is subject to ecclesiastical correction and monetary penalties. After that, the court recognized night visits by relatives as illegal interference and reinforced the ban on any advice given without summoning the chancellery. The amounts of the fines were specified in words so that they could not be corrected in the field. From now on, the fee for someone else's bed was considered as real as the fee for a broken window or a stolen sack of grain. The notary insisted that the decree include a practical part, without which any norm becomes a mere wish. The parish was to keep copies of the announcements and issue them at the request of the court. The office was to keep a collection of decrees with notes on voluntariness at hand. The doctor was to send short notes on the consequences of pressure, if it reappeared. and these notes were to be immediately included in the file. For stubborn traditionalists, the court left a direct line. Repeated violation of the ban on counseling would result in a doubling of the fine, and in the case of systematic violations, exclusion from participation in parish meetings until further notice. This was not a harsh punishment, but rather an exclusion from public influence on which their custom depended. The husband's family initially tried to make a fuss to gain a respite, but their noise was drowned out by order. The fines, recorded in writing, hit the wallets of the organizers of the feasts, and nighttime restoration of order. The household book showed how, in the week after the ruling, the expenses for gifts to the elders disappeared, and expenses for flour, salt, and firewood appeared. The house stopped feeding the outside authorities. The husband, now an adult and suddenly free from the choir, began to come to the notary alone, with a list of things to do for the household. His wife, now an adult and breathing more quietly, returned to the doctor's notes as a patient without nighttime breakdowns and tremors. No one became a saint. There were fewer foreign hands and more responsible words. In the silence of the city, this was tantamount to victory. Meanwhile, the legend continued to stir in the markets. They said that Rome once ordered beds to be kept under lock and key. The cunning tale needed an audience, and the audience loved short stories. The notary did not argue with his voice. He argued with paper. He drew up a short circular for scribes and priests. In cases involving spouses, first ask about the announcement, then about voluntariness, then about the intervention of third parties, and then about health. Only after that should they talk about the arrangement. This order seemed boring, but it was precisely this boredom that saved them from beautiful cruelty. And when the elders of another family tried to play out the authority of Rome again, they were shown not a fairy tale, but lines where the Roman chancellery demanded that consent be protected. The court brought the case to a conclusion. It recognized the intervention of the clan as illegal, ordered the traditionalists to pay fines and reimburse the costs of medical examinations, officially confirmed the right of spouses to regulate the intimate side of marriage without external inspection, provided there was no violence, and instructed the chancellery to conduct random checks of parish publications so that custom did not turn announcements into an empty formality. On the last page of the decree was a simple formula. From now on, reference to honor at home cannot be used against the will of adults in marriage. Reference to Rome must correspond to the Roman text, not the noise of the court. This decision had quiet consequences. Parish sermons changed their tone. They spoke of reciprocity as a measure of union, rather than the right of third parties to dispose of the bed. Elders, accustomed to gathering councils at night, began to cautiously ask for permission for daytime meetings in the office, and more often heard refusals. Doctors began to record fewer breakdowns among women from homes where peaceful feasts had previously been held. At the fair, people no longer argued about the right to shame, but about the price of wood. Fear ceased to be a commodity. From the chronicler's point of view, nothing miraculous happened. but from the point of view of the bodies, the source of pain, which they were accustomed to justify with the word duty, disappeared. The notary attached a small sheet of paper to the case with a title written in even handwriting: Myth and Document in the Marriage Norm. In a few dry lines, he contrasted fiction and text. In fiction, Rome imposed the bed and blessed the control of bodies by others. In the document, the Pope from the early 13th century and his chancellery defended the choice of marriage as the consent of adults and punished coercion. In fiction, duty sounds like a family club. In the document, duty is the mutual perspective of the union, for which the nightly chorus at the bedroom door is meaningless. In fiction, tradition is above the law. In the document, the law separates tradition from violence, and the court is obliged to protect this gap. He devoted the last lines to human decisions, without which the paper remains a warm rag. The husband chose home over the choir and paid for it with awkwardness in front of his relatives, and it was worth it, because the house became warmer not because of feasts, but because of the stove. The wife chose the right to say yes and no, and this right turned out to be heavier than talk of honor because it gave her sleep. The court chose a document over noise, and this choice cost it popularity in some homes, but it brought order where fear ceased to be an argument. The parish chose the charter instead of rumor, and with this choice closed the loophole through which nighttime councils used to penetrate. When the decree dried and the seal left its heavy imprint, the notary put the case away in a cabinet that smelled of leather and lamp oil. Other folders lay on the shelf nearby, some about debts and bridges, others about inheritances. In each of them, he looked for the same thing: a place where myth was convenient for the powerful, and a text that could prevent it. This time he saw how the Roman word for consent turned into protection for the living. Marriage did not become holier, but it became more honest. The custom did not disappear, but it lost the right to enter the house without knocking. And the legend of total control remained a legend, because on the table, next to the marriage contract, lay a piece of paper with the words written in black and white: "A union is not made by cries at the bedside or the chorus of relatives, but by the free will of adults. And it is precisely this that the court is obliged to protect."